Good morning. I'm attorney Gary Finklea from the Finklea Law Firm in Florence, South Carolina. Today I wish to speak to you regarding the 50th anniversary of Gideon versus Wainwright. If you want to Google that case, you can easily determine what that case is about, but it is a case and a case name that most lawyers are readily familiar with. But that case establishes the right to counsel for any person charged with a felony crime. Gideon emanates from the state of Florida. Gideon was charged with breaking and entering. He was charged, convicted in the Florida courts. The jury returned a verdict after 10 minutes. He was sentenced. He was not provided a lawyer during his trial. He appealed. He filed a writ of habeas corpus, and it was a handwritten writ of habeas corpus to the United States Supreme Court. The United States Supreme Court appointed an attorney from Washington, Abe Fortas, to represent Gideon, and the court, in a rare and unanimous decision of 9-0, reversed prior precedent that the Supreme Court had established. The precedent that was reversed was Betts v. Brady, a 1942 case that said counsel only had to be appointed in particular felony cases or particular cases such that the defendant was illiterate, mentally retarded, or there are some other issues with the case or the defendant such that a lawyer was absolutely necessary to defend the defendant. In other words, the defendant was incapable of defending himself. Also, an attorney was necessary in capital murder cases. Well, the Supreme Court again reversed that decision and held in any felony a defendant is entitled to a lawyer. That's what Gideon v. Wainwright stands for. Now, from a practical matter, what that means is if you're charged in magistrate's court or municipal court, you're not required to have a lawyer. The state is not required to provide one for you. Likewise, in circuit court, if the charge will not result in jail time or could not result in jail time, you do not have to be appointed or provided a lawyer. But in circuit court, of course, all offenses could result in jail time. So you always have that right that I'm aware of in circuit court. As another practical matter, or as for the rest of the story, as Paul Harvey would say, Gideon was retried in the Florida court, and at that time he was, of course, represented by a lawyer. The lawyer called many witnesses, including a taxi cab driver who provided an alibi or corroborated Gideon's story that when he allegedly broke and entered into this establishment, that the allegation was that he stole money, cigarettes, and things like that. But the cab driver testified when he picked him up from that area, he had none of those things on his possession. Anyway, unlike the first jury who returned a verdict in 10 minutes for guilty, this jury found him not guilty and he was free to go. So we celebrate the 50th anniversary of Gideon v. Wainwright. If you have any questions concerning a criminal matter or your right to counsel, please feel free to contact the Finklea Law Firm at 843-317-4900, or you can email me, gfinklea@finkleylaw.com, or reach us on the web, finkleylaw.com. Thank you very much.